Let's talk about the buyer, the protections that are in the contract for the buyer, for the broker, sorry, the protections that are in the contract for the broker. As you know, AIR is a broker organization. We don't make a secret of it. The contracts are printed to protect the brokers, and some of the protections in the contract I'm going to highlight here so you can make a note of all these provisions to strike. If you're representing the buyer or the seller. Section 7.1, the last sentence says that the buyer will use the buyer's broker exclusively for negotiating any deals with this property for 1 year. This was really meant to be a prophylactic provision to prevent a buyer and a seller colluding with each other near the end of a listing to say, you know what, don't respond to my offer. Let's wait till the listing expires. Then I'll come back and we'll make a deal. We'll save the commission or we'll split the commission. That way we can avoid paying the buyer's broker or the seller's broker or any broker at all. So this is meant to prevent a buyer and a seller colluding with each other to run out the clock on a listing and then make a deal without the brokers. What's happened in California, we had the AB 2992 that became effective January 1, 2025, which requires every broker representing a buyer to have a buyer-broker representation agreement. That's the law now. So this is less of a concern for the buyer's broker because they will be protected by the buyer-broker representation agreement. Most seller brokers have a registration period in their listing agreement, so this may not be as critical with the passage of AB 2992 in California.
So, Bryan, we have 3 slides and about 4 minutes of the
I'm almost done here, Howard.
Great.
So section 9.1 is the payment of the commission at the closing. This is very often stricken. And it doesn't really, that's very often happens. The next one is section 18.1. This is important. The party who defaults has to pay the broker the fee that the broker would have been paid. If the buyer is the defaulting party, the buyer owes the broker's fee in addition to any liquidated damages. So this is a very important provision to pay attention to, 18.1. 24.1 is 2 provisions. One is that says that the reduces the statute of limitation for suing the broker to 1 year after the date of agreement and puts a cap on the amount of the broker's exposure to the amount of the fee that was received by the broker from the transaction.